We're ready to go. So we'll go on the record. This is People versus Jamie Rochelau, case number 246708. If I could have counsel put your appearances on.
Anna Berger appearing on behalf of the people.
Luke Pesky on behalf of Mr. Rochelau, Your Honor.
Okay, so this is set for a hearing today. The people filed a notice of intent to introduce some other acts evidence, and Mr. Witkowski filed a objection to that. I had a chance to review your objection as well as the initial notice that was filed by the prosecutor. We could certainly take some oral argument today. I don't know, in reviewing this, it seems to me that may need to take some testimony before the court can rule on this. Ms. Brucker, what's your position on that? I mean, typically the people would have the burden of showing that the evidence qualifies either under the statute or for a proper purpose under 404B.
Correct, Judge. And to be candid, Judge, I don't think Mr. Rolla subpoenaed any witnesses for today. I think we anticipated to be more legal oral argument. So I'd ask if the court would like testimony, if we could just adjourn this so we can get witnesses and have that testimony for the court.
All right, Mr. Witkowski.
Well, Your Honor, I think reviewing the brief that I submitted, it certainly can understand the court's position there. The other acts evidence, there's very scant support for that and information regarding that evidence. I'm not opposed to, if the court wants to adjourn this matter briefly for additional time to bring in a witness to testify to those acts, the validity of those acts, some of that information.
Yeah, I mean, looking at this, to me, there's certainly legal issues involved, but I think the court needs to have some evidence in the record as to exactly what this evidence is that was found, how much of it was found, where it was found. I mean, all of those things I think are going to go to its admissibility under either the statute or 404B. And I don't think I can make a proper ruling based on just assertions in briefs. I don't really fault the people. This was, kind of set for a 15-minute hearing here on motion day. So I think it's reasonable for them to not look at this as an evidentiary hearing. I think probably it may be an hour or two hearing that we would need to set aside. Ms. Brucker, I mean, how many witnesses do you think you would need to call here to testify as to how and under what circumstances and what this evidence that was found is?
Probably at least a couple witnesses, Judge. 1 or 2 hours sounds about right.
Okay, Mr. Witkowski.
I would agree, Your Honor. 1 or 2 hours seems appropriate. I guess I can't speak to how many witnesses they'd like to call to present that information, but certainly a couple hours would be necessary. And of course, I know the other acts evidence or notice was submitted back last year. I submitted my response or objections in December, and there's been no response to that brief or otherwise from the people in preparation of this hearing today. I know we have a trial looming here mid-March. So I'm just curious when we could have that hearing done. I do anticipate filing a motion and having a evidentiary hearing regarding this evidence as well in Sheboygan County, where the case is that he's looking at the other acts evidence allegedly happening as well. So all that would be fruitful to the court's determination on admissibility.
Okay, so yeah, we have trial dates scheduled in about a month and a half. So I think we should be able to get that set for hearing well in advance of that time. And I would anticipate ruling on the motions at the time of the hearing. So it's not like it would be further delayed for the court to issue a ruling.
Very good, Your Honor.
So we'll schedule this for a 2-hour evidentiary hearing at the court's next available date. Go forward from there. Ms. Kruger, anything further to address in this file today?
No, Your Honor.
Mr. Witkowski.
Nothing from the defense, Your Honor.
All right, thank you.
Thank you, Your Honor.
That's all for today.
You're great, Your Honor.
Thanks. Next file is with Mr. St. Or.
Yeah.
Sometimes we have.
Mr. Trish, have you had any contact with him? We're a little bit ahead of schedule. I'm just asking you, just generally.
So he did reach out to my office last week, although I've never been able to actually touch base with him. I've called him several times and he's called me, but we have not actually touched base.
Your Honor, someone's coming through this security right now. I'm not sure if that's him or not. Sorry.
All right, rather than stay on the record, we are ahead of schedule, so let's take a short recess and we'll come back on the record at 9:15. We're on record in People versus St. Moore, case number 246764. The record should reflect Mr. St. Moore's present here in the courtroom today. If I could have counsel.
And the record appearing on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Sanamore.
This was set for a sentencing hearing today. I am in receipt of a case report from Agent Brunical, who was the agent assigned to do the pre-sentence report in this case. In that case report, he's outlined a number of attempts to reach Mr. Sanamore for preparation of a pre-sentence report, and indicates that he failed to get cooperation from Mr. Sanamore. So I guess, Mr. Trush, I'd be asking your client to explain why he hasn't cooperated with the pre-sentence process here.
Well, so Your Honor, I think there's a couple of things going on. So Mr. Bernicall reached out to me in mid-January, asking for contact information for Mr. Sanamore. I provided him with 2 phone numbers that I had for Mr. Sanamore, but I don't think they were accurate numbers. He contacted me last week from a number that's different than the 2 that I had provided to Mr. Bernicall. Mr. Sanamore has indicated to me after he contacted me, I gave him Mr. Bernicall's contact info, told him get in touch with them right away. Even though we're not likely to be able to get a report done, at least making this contact is a good thing. He reports that he reached out to Mr. Bernicall, has not heard back from him yet. I spoke to Ms. Davis about that today. I think she's indicated that Mr. Bernicall said he hadn't heard from him yet. But that's the update that I can provide to the court is, at least I think I bear some of the responsibility for not providing Mr. Bernicall with accurate numbers.
Ms. Bruker, do people take any position?
I would defer to Ms. Davis if she has anything additional to add prior to the contacts.
Okay, Ms. Davis, anything additional?
Nothing more than what we report now.
Okay, all right. First of all, I mean, the phone numbers, I don't think that's your fault, Mr. Trush. Mr. Sanamore, it's up to him to make sure that you have correct numbers for him. I view that, Mr. Sanamore, that's on you for not providing the proper information to your attorney. The pre-sentence report process is a crucial step in the case, one that you're required to comply with. I have no reason to doubt Mr. Brunical. He's got no reason to make up any of the facts that he put in his report, and no reason to state that you haven't contacted him. In fact, you've been trying to contact him. So at this point, we do need to move forward with sentencing. I think the best way to ensure that is to have you in custody so we know where you're at, we can complete the report. So based on your failure to comply, the court is going to revoke your bond, order that you be taken into custody today. The court will set this for a sentencing hearing at its next available date. And Ms. Davis, if you could just notify Agent Brunical that Mr. Sanamore will be lodged, and you can contact him at the jail for the pre-sentence report. So, yeah.
When do you want the next hearing scheduled?
We'll set it, Jen will set it for our next available.
Okay.
Yeah. Our next hearing is set for 9:30. We'll take a short recess until that time. Record is People versus Barber, case number 246767. The record should reflect Mr. Barber's present here in the courtroom today. If I can have the council put your appearances on.
And a burger, people.
Here at Eagle on behalf of Mr. Barber.
This is the date and time set for a sentencing hearing in this case. Mr. Barber, have you had an opportunity to go through the pre-sentence report and talk to Mr. Kilo about that?
Yes, sir.
Okay. Mr. Kilo, are there any additions, deletions, or corrections to that report?
None, Your Honor. Thank you.
Are there any challenges to the scoring of the guidelines?
No challenges to the scoring.
I do want to state for the record, I received a report from Ms. Van Wolfen from the Community Corrections Pretrial Supervision program, and I had a chance to review that report as well. Ms. Bruker, do the people have any additions, deletions, or corrections?
No corrections and no challenges to the scoring.
Mr. Gilo, can you move that podium? That way I can't see Ms. Bruker.
Pick it
Set
up.
this voice.
That one,
There we go. All right, any challenges to the scoring, Ms. Bruker?
No, Your Honor.
All right, anything on behalf of the people for allocution today?
Your Honor, the guidelines are 10 to 23, and then DOC is recommending a period in the county jail up to 12 months. I would ask the court to follow that recommendation on the basis of defendants' pretty recent incarceration in another county, and the fact that he was defended almost immediately. He was released from that period of incarceration.
Thank you, Mr. Gilo.
Well, I'd ask the court to deviate from the recommendation based on the excuse me. Based on the fact that he has always admitted to a crime that he's committed. He did go to inpatient treatment. I think the court has a copy of that completion. He just completed that, showing that he's serious about taking care of his drug problem. This isn't a delivery charge, it's a simple possession charge. Now, I understand my client's record follows him, and the court has to take that into consideration. But also take into consideration that in all of his crimes that he's committed, he's always admitted to them. He's never taken anything to trial. And like I said, he graduated from the Harbor Hall substance abuse treatment, which indicates to the court, I think, at least to me, that he's taking this seriously. So I respectfully request that the court might consider lesser charge, lesser incarceration than what's recommended. Perhaps maybe 6 months in Otsego County Jail would be appropriate.
Thank you, Mr. Barber. Anything that you wanted to say today?
Yes, Your Honor, that, I didn't take full responsibility for my actions and what I did. And I know I got a drug problem and I am trying to fix it. I'm sorry.
Okay. I did read through the report, so I'm familiar with what happened in this case. I'm also familiar with your past history and your record based on the information in that report. And, I think there's competing factors here that the court has to take into consideration in terms of your sentence. The negatives, of course, are your past record. You've got 8 prior felonies. You've been on probation a number of times, jail a number of times. I think one time, one prior prison sentence. And up until now, at least, none of those things have managed to make an impact to the extent that you change things. And Ms. Brewer's right, you had some charges that you were recently released from earlier in 2024, and then immediately had this case come up. So those things all give me some pause in terms of your ability to work from this and not reoffend. The positives, when I reviewed the community corrections report, you were in their program for 107 days, so a little over 3 months, 3.5 months. Ms. Van Wolfen indicates that you were fully compliant with that program, that you followed through with the recommendations that were made by your therapist, that you completed your program in Harbor Hall and then the transition house after that. And even when you were participating in those, you continued to check in and comply with all the requirements of pretrial supervision. And so those things, along with what Mr. Hilo said in terms of your willingness to seek treatment, follow through with that, I think are mitigating factors that provide some indication that you are trying to address this issue and move on. So in terms of balancing those two, number one, I don't find, even though the guidelines could call for a prison sentence, I don't think that that's appropriate given your efforts to rehabilitate during the pendency of this case. I think that would only set things back for you to the extent that you made progress. But I also don't think there's any reason to go below the guidelines in this case. There aren't any compelling factors that would lead this court to find that based on your past history and your conduct here that that your sentence should be below what the guidelines are. So I think a sentence with a community sanction within the guidelines at the low end addresses your prior history and continuing to reoffend, but also grant you some credit for mitigating factors and for the treatment that you sought during the pendency of this case. So I think it does take into account all of those things. So, and that is what the recommendation is, and I think it's an appropriate recommendation. So the court is going to sentence you to 12 months in the Otsego County Jail. You have credit for 2 days served. Because this is a non-violent crime, non-assaultive crime, because it doesn't involve delivery of methamphetamine, it's a possession charge. And given your efforts at rehabilitation during the pendency of this case, I don't have any objection to your immediate release to work camp. So participation in the work camp program as opposed to jail. That'll be up to the jail first to make sure that you qualify for the program, but I don't have any objection to release to the work camp program. You do have the ability, I'm sorry, the court is also going to impose crime victims assessment of $130, court costs of $300, attorney fees of $325, attorney fees of $350, and a state cost of $68. You do have the ability to seek an appeal of the sentence. Mr. Hilo, do you have Mr. Barber?
I do, Judge. What's the date today?
February
6th?
5th.
That's what I thought.
I have court costs as $130.
Yeah, that's it. Can you let me know once Mr. Barber has acknowledged or submitted his appellate right, please?
For the record, my client signed his receipt of and handed a copy of whoops, that goes this goes to the court.
Yeah, no, that's no, his bonds was being revoked.
All right, thanks.
Our next hearing's at 9:45 with Mr. McKinnon. We'll take a short break. we're on the record in People versus Kenneth McKinnon, case number 246698. If I could have counsel for the appearances on.
And a burger if you're gonna have people.
Thank you, Your Honor. Richard Tushku on behalf of Mr. McKinnon.
Right, this is the date and time set for sentencing in this matter. Mr. McKinnon was found guilty of a probation violation after a hearing a couple weeks ago. And today was set as the sentencing date. It was set for 9:45. It's now 9:50. Mr. McKinnon is not present. Mr. Trush, have you had any contacts with him?
I have. I've had contact with him over the last week or so, discussing with him the recommendations and such. He was aware of the court date. I'll leave it at that.
Okay. Ms. Bruker, anything for the people?
I asked the court to consider a bench warrant given that he was aware of the court date. Hopefully not show up today.
All right, in light of the court's findings on the probation violation as well as the probable sentence and Mr. McKinnon's failure to appear today, I think it would be appropriate to issue a warrant for his arrest. The court will order that Mr. McKinnon's bond be revoked and that once he's arrested that he be held without bond. Court will set a sentencing hearing for the next possible date after Mr. McKinnon is arrested. Ms. Bruker, anything further on this file today?
Judge, is that paperwork that we have to prepare?
Yes. Mr. Church?
Nothing further.
Okay. All right, thank you. Next hearing set for 10:15 will be in recess until that.
Good morning.
Right, good morning, Ms. Siegel. We're on the record now in People versus Stephen David Rao, case number 134686. If I could have both counsel put your appearances on, please.
Amanda Brooker appearing on behalf of people.
Ashley Siegel for Stephen Rao.
Thank you. This is set for hearing on defendant's motion for resentencing, and I think I saw a communication, Ms. Siegel, indicating that Mr. Rao was not going to be able to be present today, but that he waived his presence for the purposes of this hearing. Is that correct?
That's correct, Your Honor.
Okay. I did have a chance to review the briefs of the parties. I also had an opportunity to review the transcript of the sentencing hearing. Ms. Siegel, is there anything that you wanted to present by way of oral argument for your motion today?
No, Your Honor.
I have nothing else to add, Your Honor, either.
Okay. All right. And Ms. Siegel, correct me if I'm wrong, but your motion is based on the fact that the court did not appropriately refer to the guidelines when sentencing Mr. Rao on this probation violation, and did not properly articulate the reasons for the departure or the extent of the departure. Is that essentially your grounds?
I believe Mr. Rao's argument is basically that, yes, Your Honor, you summed it up just right. He understands that the court was looking at all of the facts and circumstances and decided to sentence him up near the top, but didn't feel that the court took appropriate notice and consideration of the actual guidelines and how low those really were in its departure. Or not departure, I'm sorry, it wasn't a departure, but in its decision to, oh, now I'm sorry. Was it a departure? I don't recall now.
It was, yeah.
It was, yes, Your Honor, I'm sorry. Right, because the prosecution was arguing for the max allowable, considering the Tanner rule. The court didn't quite go all that way, but the court did depart, and Mr. Rao's argument or concern was that the court didn't really take fully into consideration how much lower the guidelines were than the court's ultimate sentence.
Okay, all right, thank you. Again, so addressing the arguments of the defendant here, first of all, in my view, the court did take into account the original guidelines. I think some of the most important factors here for purposes of sentencing was the fact that this was a sentencing on a probation violation, and what the court felt was an appropriate sentence was based on Mr. Rao's underlying behavior, but even more so on his behavior while he was on probation. And so the original guidelines obviously did not take into account his behavior while on probation. And so when the court looked at the guidelines, which I believe were 0 to 13 on the underlying charge, a lot had happened. Mr. Rao had absconded, I think, for about 10 years at the point that he was finally brought to answer for his probation violation. So there was a lot of behavior in the interim by Mr. Rao, which in the court's view made the original guidelines really completely inapplicable to his behavior in terms of what an appropriate sentence was for the probation violation. The original charge was scored under an E grid, and as it was scored originally, again, the offense variables did not take into account any of his subsequent behavior while he was on probation. And so when the court looked at that grid and tried to determine, number one, what an appropriate sentence was, which the court found to be a departure from 0 to 13, but also the extent of that departure, the court looked at, if that conduct had been scored, what kind of range would that have resulted in? And it was my conclusion that his conduct while on probation was egregious enough that it should have resulted in a maximum score on the OB level, which as a habitual second on that grid would have resulted in a range of 21 months to 47 months at the high end of that range. And so, number one, I think the court articulated on the record at sentencing its reasons for a departure in the first place, and I'm going to rely on my statements there in terms of the basis for the departure. I may not have properly or fully articulated my reasons for the extent of the departure. And so, again, looking at that E-grid, if those OVs had been maxed out, which I think his conduct while on probation should have resulted in an extremely high OV score, we get that range of 21 months to 47 months at the high end. As Ms. Siegel correctly pointed out, a prosecutor at sentencing urged the court to sentence Mr. Rao to the maximum allowable under the Tanner 2/3 rule. The court did not go that high, didn't feel that the facts justified that level of departure. But the court, again, grounding its degree of departure in the guidelines in the E-grid at a maximum OB of 21 to 47 months, decided that 40 months was logically connected to the guidelines. It was a logical adjustment to those guidelines based on his conduct while on probation. Logically connected to a high OB score, which would have been justified based on his behavior on probation. It wasn't just a random number that the court picked or made up or came up with. Again, it was rooted in the guidelines. It was rooted in Mr. Rao's conduct while on probation, and was connected to those guidelines in the sentencing grid. And again, one that I find is justified by his post-conviction behavior. So for those reasons, the court finds that it did properly articulate the departure at the time of sentencing, that based on my additional statements here today in terms of the degree of departure, the court finds that, again, it's grounded with due regard to the guidelines and the scoring and Mr. Rao's post-conviction behavior. So that for those reasons, the court will deny the motion for resentencing. And Ms. Siegel, I would ask that you prepare an order and submit that to the court.
Your Honor, I generally do, and I believe I did in this matter, provide an order both granting and denying. Does the court have that in its file?
Let me take a look. You may have, and perhaps I just missed it, so. I am not seeing it in here.
I
So-
do have them in my file. I can send them right over. Would the court like me to call or email or mail those in?
So your proof of service does indicate that it was sent with your motion. I'm just not seeing it in the file here.
I typically
So,
include
yeah.
a copy for filing as well as a judge's copy.
Yeah, so I don't know if you can resend it,
Um,
that might be easier, because I'm not seeing it right here.
Okay, will do, Your Honor. Thank you.
Okay, all right, Ms. Siegel, anything further we need to address for the record today?
Nothing else.
Ms. Brooker?
No, Your Honor.
Okay, thank you, Ms. Siegel. You're free to disconnect at this time.
Thank you.
You let Mr. Church know. Oh, he's gonna appear remote.
Yes, he had to get court profit.
Oh, yeah.
All right, I don't see Mr. Church connected yet, so we'll take a short break. right, Mr. Trush, are you able to hear me okay?
Yes, Your Honor.
Okay, we're on the record now in People versus Haas, file number 246776, 6779, and 6780. The record should reflect Mr. Haas is present here in the courtroom today. If I could have counsel put your appearances on.
Anna Berger, attorney on behalf of the people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Joey Haas.
Thank you, I'm sorry, Ms. Bruker, this is the people's motion to consolidate. Can you place your argument on the record for today's court?
Your Honor, Mr. Haas has a number of files against him. We did hold a contested preliminary exam in this case as well. We're asking that the court join these cases for trial due to the related nature of these charges and the number of witnesses that overlap in this case. To give the court an offer of proof, what would the court like me to give an offer of proof as the facts?
Sure.
Okay. Defendant allegedly stole a truck, drove that truck to the victim in the aggravated stalking's case's home, abandoned that truck. The victim in the aggravated stalking notified the police, and that was when these two investigations of the stolen truck and the aggravated stalking came together. So he was charged with aggravated stalking because the victim had a personal protection order against Mr. Haas. There are also a couple of other contacts regarding the personal protection order that will be part of the case involving the aggravated stalking that are unrelated to the events of that evening. He was charged with unlawful driving away due to stealing the vehicle. So if the court does not join these cases, in the two cases, well, even if the court does join these two cases, we'll be filing 404B notices on both of the files to admit the evidence of the other crimes that will go towards the plan, absence of mistake, motive on those cases as well. So these occurrences are close enough in proximity of time. The number of witnesses will be almost the same in both the cases. There may be a couple of other witnesses regarding the unlawful driving away of a vehicle that don't relate to the aggravated stalking. Police officers involved in both cases are similar. So they're close enough in proximity and so forth that it would make sense for us to try these cases together. We did hold the preliminary exams together done in district court as well. So we would ask the court to join these cases for trial.
And it's all three files, correct?
Correct, sorry.
Thank you. Mr. Trush?
Thank you, Your Honor. Our position is we don't oppose the joinder of the UDAA files. I would oppose the joinder in regards to the aggravated stalking file. Again, while I certainly understand that there is some overlap between these cases, the aggravated stalking file has a much broader scope than the other two cases. The other two cases occur on the same date. I mean, I think there is connection there. The aggravated stalking, necessarily, we have to get into the underlying facts of that there is a PPO in place, and then there has to be a pattern of violations, only one of which of those is alleged to have occurred on the date of the other offenses. So I think when you balance the prejudicial value of having everything joined with the fact that, again, only one of the instances of contact occurs on that date, I think the balance comes out in favor of not joining the aggravated stalking. I would also indicate, at least insofar as the prosecutor's argument about absence of mistake or motive, I mean, one, that I don't think any of those things are really issues in this case. Motive is not required for any of the charges. Mistake has not been raised or is not going to be alleged as a defense in any of them. So I don't think that holds much weight. Thank you.
All right, Ms. Bruker, any responses?
Just a response to that, I think the court could cure any of the concerns about the personal protection order and its relevance to the other charges of some kind of limiting instruction on that. The incident that caused the aggravated stalking charges to be filed occurred the evening of the UDAA with him coming to the victim's house. There are, like I said initially, there are a couple of other contacts that obviously we'll have to prove the aggravated stalking, but I don't think that will cause any prejudice to the defendant that can't be cured by an instruction.
All right, thank you. The court looks at joinder when a single defendant is involved. The court looks at joinder under MCR 6.120 B is the applicable court rule in this case because they weren't charged together. This is post-charging permissive joinder. On the motion of any party or by stipulation, the court can join different offenses from separate informations or indictments against a single defendant into one for purposes of trial. And that's appropriate when it promotes fairness to the parties and a fair determination of the defendant's guilt or innocence of each offense. Under 6.120B1, joinder is appropriate if the offenses are related. That court rule defines related offenses as offenses that are part of the same conduct or transaction, or a series of connected acts, or a series of acts constituting parts of a single scheme or plan. The court also must take into account under sub B2 other factors such as the timeliness of the motion, the drain on the party's resources, the potential for confusion or prejudice stemming either from the number of charges or the complexity or the nature of the evidence, the potential for harassment, the convenience of the witnesses, and the party's readiness for trial. Looking at all of those factors together, the court finds that it does qualify for joinder under 6.120B1B, a series of connected acts. Clearly, these offenses all took place within the same period of time. The acts are connected to the extent that they involve kind of one prolonged, in my view, course of conduct on behalf of Mr. Haas. And certainly timeliness is not an issue. I think drain on the party's resources actually works in favor of trying these together. I think to the extent that there is any confusion that would result, I agree with Ms. Brucker that an instruction to the jury would cure that. And I think having these tried together because they are so closely connected in time and are, again, in my view, one long course of conduct by the defendant, I think trying these together does provide the jury with a much better view of whether the defendant is guilty or innocent of these crimes when looked at as a whole and tried together. So for all those reasons, the court finds that prosecutors met their burden under 6.120 to show that joinder should be appropriate, and the court will grant the motion. Ms. Brucker, if you will submit an order either with a stipulation as to form or under the seven-day rule on that. This is not set for a status conference today. We had a scheduling hearing in this case. Do we have a trial date? Any of these files set?
I think we have a trial date.
Yeah, let me look real quick.
I do believe that we have trial dates.
In April.
Okay.
Yep, April.
Okay, so Ms. Kruger, if you could just, in that order, indicate that all files be consolidated for trial on that April date. Work from there, Ms. Kruger. Anything further we need to address today?
No, Your Honor.
Mr. Trush, anything further?
Not for today's record, thank you.
Mr. Haas, did you have any questions? No. All right, thank you. That's all for today on this hearing. Mr. Trush, you're free to disconnect at this time. All right, Mr. Engelson, are you there?
I am, Your Honor. Good morning.
Okay, good morning. All right, we're on the record now in Van Wormer versus Trozak. This is Emmett County file number 241085553. I'm presiding over this case by assignment from the State Court Administrator's Office. This is set for a status conference today. Mr. Engelson, you're appearing on behalf of plaintiffs.
Correct.
Or plaintiff, okay. This was set for status conference today at 11:30. It's now 11:35 by my clock. Mr. Trozak is not present in the Zoom waiting room. As I stated, this is set for a status conference today. I believe this is at least the third status conference that's been set since the court granted the preliminary injunction after the TRO was entered. Mr. Trozak has not appeared for any of the hearings. So I don't know, Mr. Engelson, how you want to proceed today. I do want to get, I guess, some cutoff dates set. I'm not sure, you know, in light of Mr. Trozak's failure to appear in any hearings that, you know, whether you're going to proceed with default, whether you have motions that you're going to file. Can you kind of tell me where things are at from your standpoint?
As a preliminary matter, the last scheduling conference, I missed it. I sent an apology to the court and Mr. Trozak. I just want to state that on the record as well, Your Honor. In regard to your inquiry about how I see us proceeding, in the absence of Mr. Trozak participating, my plan would be to file a default and seek a default judgment. And the issue, as long as everything remains the same, for a default or default judgment only, would be the costs associated with having to take the steps to ensure that my clients have gas service to their units, so their furnaces run, and I have receipts for those things. I'll submit them to the court, and I would also submit for consideration the costs and fees associated with us having to seek enforcement of the prior judgment. And I will do that. We can, I don't know if you want to set a deadline for any sort of participation by Mr. Trozak. I don't know whether he will or he won't. But I would file a motion, get a hearing date from the court for a default judgment, which, if the court gave it to me, it'd probably be in the next 28 days, something like that.
Okay, all right. I'm not going to build in any more time for Mr. Trozak. I've delayed it twice, I think, to give him an opportunity to appear. So I think we need to move forward with the case. I'm going to set a deadline for 60 days for any dispositive motions, whether that's motions for summary or motions for entry of default judgment, however you want to proceed procedurally. But I'm going to set the 60-day deadline for those to be filed and set for hearing. And that'll apply to both sides. If Mr. Trozak does decide to participate, that deadline will apply to all parties. So to him as well. And then I'm going to set this for a status conference at 60 days. I'm assuming that at least you will be filing something and we'll have a hearing on that prior to that, but that status conference at 60 days will be a control date so that if for some reason nothing is filed, then that'll give us a date to see where things are at. Because as you're aware, the court under the court rule is under a time limit here to have a final hearing one way or the other.
Understood.
So I will put that into the status conference order for today. And anything else I can address for your side today?
Nothing else, Your Honor. Thank you.
Okay, thank you. That's all for today, and you're free to disconnect.
All right. Have a good day. Thanks.
That also concludes the court's morning docket. The court will be in recess until 3:50.